Welcome everyone. Welcome everyone to the San Fernando Valley Bar Association's Taxation Law Section. This is our first webinar for the 2025-2026 fiscal year, and I'm so glad everybody has joined us. Before I introduce our speakers and let them get started with the presentation, a couple of housekeeping announcements. Number one, we have the big installation of the San Fernando Valley Bar Association officers and the Valley Community Legal Foundation installation gala on November 13th. Information is on the sfvba.org website, or if you need information and to register, you can reach out to Linda at events@sfvba.org. Next month, I invited Richard Grandman to speak on the OBA, the One Big Beautiful Bill Act, and that will be the taxation section webinar will be on October 21st. But today, I invited David Warner and Richard Gano from Holtz, Slavett Drabkin. David has spoken to us before, 1 or 2 years ago. And the topic they're going to be presenting on is IRS audits of high net worth and global families. Just a couple of quick comments about their backgrounds. Both are former IRS lawyers. David was here in the Southern California area in LA and Orange County, and Richard was in Washington, D.C. prior to joining the firm. David is a graduate of the University of Minnesota, Loyola Law School, and New York University. And Richard is a graduate of CSUN, Loyola Law School with a JD and a Master of Laws. Thank you, gentlemen, for presenting, and really looking forward to this discussion.
Thanks, Rach. We're happy to be here. Yeah, like Rach said, today we're going to be talking about IRS audits of global high wealth individuals, kind of the procedural aspects of that, about how these audits may differ from normal IRS audits, as well as what are some common issues, hot button areas that they're focused on, that there are specific subject matter experts or particular areas of interest for the IRS. And some of these areas of interest that we'll get into, like we'll talk about, are areas of interest for all IRS audits, not just global high wealth individuals, but it will kind of talk about it in the framework of those type of audits. There. First about me, as Raj mentioned, my name is David Warner. I'm a shareholder with Holtz, Slavett Drabkin. We are a tax controversy firm with 9 former IRS attorneys, where we handle any kind of dispute with the tax agency, whether it's the IRS or state tax agencies, whether it's income, sales tax, anything, payroll taxes, we handle it. Before joining Holtz, Slavett Drabkin, I was an attorney in the IRS Office of Chief Counsel for 9 years. I was a senior trial attorney based out of Laguna Niguel mainly. And there, I was a founding member of the Southwestern Area Partnership Cadre. I advised revenue agents on complex audits involving all types of issues, whether it be offshore issues, partnerships and S-corp matters, potential criminal referrals. I also was a DOJ Special Assistant U.S. Attorney handling the intersection of tax and bankruptcy. And as Raj mentioned, I have my tax LLM from NYU. Richard, do you want to introduce yourself?
Sure. So similar to David, we practice in tax controversy, which involves civil and criminal tax, matters, which tax audits, litigation, collection issues. We represent individuals and businesses in IRS and state tax audits, as well as litigation in U.S. Tax Court, U.S. District Court, and Court of Federal Claims. As alluded to, I used to work at the IRS before joining the firm. I worked at the Washington, D.C., the national headquarters of the IRS, specifically in the Income Tax and Accounting Division. There I analyzed complex situations involving conservation easements, individual and business tax deductions, as well as timing issues related to when to report income, when to take deductions. I served as a subject matter expert in alimony and separate maintenance payments, trade and business expenses, and the medical expense deduction. In addition, I assisted on drafting guidance related to charitable conservation easements, which is a topic we'll be talking about today, deductions and guidance related to capitalization of intangible assets. So what we're going to be talking about today is high net worth examinations. The idea is that the focus of these high net worth or high income examinations is to focus on is essentially high income or high net worth individuals or taxpayers. The idea is that there's going to be examinations of hundreds of these types of taxpayers. It's going to incorporate the global high wealth industry group, or the wealth squad, which are highly specialized and experienced group of agents. These examinations are complex and require a large wealth of knowledge in order to be able to handle these types of examinations. Increased data analytics, and the expectation is that there's going to be several hundred examinations of high net worth taxpayers each year. So let's talk about a little bit of the process. So it's going to start generally with the entire tax return of an individual taxpayer, looking at income and assets. The initial focus is on the individual with tens of millions of dollars in assets and income. It's going to be a broad scope and very comprehensive. Think about, a lot of these taxpayers probably have a lot of assets, a lot of flow-through entities related to them that they receive income from or have ownership in. And so it's not only just going to be the personal returns, it's going to be returns of related entities and sort of, I call it sort of the spider web and the flow chart of how all of these different entities or taxpayers fit together. It's going to encompass a review of both the Tax Cuts and Jobs Act as well as the CARES Act. And, as most recently, which we'll see probably in not before too long, is the One Big Beautiful Bill Act, the OBBBA. We'll talk a little bit about that later. So specifically some of the code sections, 199 Cap A, qualified business income deduction, Section 163J, the business interest deduction limitations, Section 965, which relates to repatriation of previously untaxed foreign earnings, and Section 172 related to net operating loss for refund claims. In addition, there's some foreign offshore assets and income that plays into that, and David will talk about that later. So how do these things start? Well, first thing, especially when clients come to us, and they're being picked up for audit, the IRS wants to learn about them. So how do they do that? The IRS issues Form 4564, an information document request, or short form is just called an IDR. And this is a sort of what I call getting to know you, especially on the initial correspondence. The IRS may not know what goes on, and many times they don't. So it's a getting to know you, especially initially. The exam will conduct, the IRS will conduct an enterprise analysis of related entities. The team, especially for high wealth, high income individuals, is going to be comprised of flow-through specialists, international examiners, economists, appraisal experts, and technical advisors. And sort of what I want to get across is it may start in an individual or one, business, but it may very likely relate and then start to, go off into other companies or other taxpayers. And that's why the IRS is going to need all these sort of specialists to understand the complexity of what's going on. IDRs are generally pretty comprehensive. They're going to request, org charts to understand how the company or how the individual operates, tax preparation work papers, tax opinions related to any return under examination, right? Is there an opinion that was relied upon? List of assets, either tangible or intangible, that were either sold or transferred. That relates a lot to the estate planning side of things. Any properties directly or indirectly leased or rented to make sure that, what's going on there. Fees paid with regard to tax or estate planning. And any properties, if interest or signature authority over foreign financial accounts with an excess of over $10,000. That's, in short, FBARs, foreign disclosures. And David will talk about that, as I mentioned earlier. And so what are these IDRs, these information document requests? Well, what happens? A failure to comply with IDRs can result in issuance of an administrative summons. So it's important to have someone that, understands the process, knows what's going on, how to respond, making sure, being able to interact with the IRS. And that's the value that David and myself and our firm provides. So sort of when I think about this, the low-hanging fruit of when it comes to high income or high wealth or what, non-filers, right? Because there's probably, especially when there's high income delinquent, a focus on that, which is what the IRS is doing. Why? Because there's significant potential income, right? You're talking about no return at all. Is there income? Is there not income? There's a potential significant income as opposed to those that file. And so that's where the focus is sort of the low-hanging fruit, the non-filers, specifically individuals with income of over $100,000 a year, generally over 3+ years of unfiled returns. So we're talking about, several years of not filing. Egregious non-compliance or indicators are generally indicators of potential fraud. Doesn't mean there is fraud, but when you have, sort of egregious non-compliance, multiple years, that, it sort of lends itself to maybe more of an indication of fraud. And that's something that, we try to keep our clients away from. So what to expect? So alluded to earlier that these cases are assigned to generally pretty experienced revenue agents. Revenue agent is an examiner. There can be unannounced and even announced office field visits, offices or homes, collaboration and coordination between Office of Fraud Enforcement, collection and examination. Really all hands on deck approach the IRS is taking. Significant use of data analytics. Use of what's called the substitute for returns. Substitute for return, for all intents and purposes, is a return for non-filers when people haven't filed. The IRS can essentially prepare its own form of a return, and that's called a substitute for return in order to assess tax against the taxpayer. What can happen is referrals to exam and even to criminal investigation. And so it's as I said, it's an all hands on deck approach. Sort of high level, what we advise clients and how we, how we approach this. Well, especially with, non-filers, the first step is, can we get some of these delinquent returns filed, right? What's the purpose of that? Number one is that there's its own obligation, right? Paying a tax and filing a tax return are two separate obligations. And while they are, kind of related for most people, I always remind clients that filing is its own obligation, even if you're going to owe tax. So why do you want to, first thing to do is maybe file these returns is number one, limit penalties. There's penalties for late filing. In addition, there could be other things, right, that I'll get to shortly. And it just mitigates the fraud referrals, right? As I said, not filing a return, and there turns out there's a lot of issues there. That could potentially be an indication of fraud. Filing compliance, also what I call a meaningful engagement with the IRS. The IRS, in order to come up with sort of a payment alternative, if you're not going to pay your tax in full, to get into a payment plan or to find out if there is a compromise available, the IRS is going to require what's filing compliance, which means filing your missing tax returns. So the tax returns, getting returns filed, are really the key that opens the door to potentially whatever is next in this case. And so let's say that there is potential criminal exposure. The IRS has what's called the voluntary disclosure practice. These are cases with potential criminal exposure. As I mentioned, there's egregious behavior, and it's sort of, it when you see it. David and I, our experience and our firm's experience, we're able to identify these types of things. And the voluntary disclosure practice is the idea the IRS wants people to come out of the dark, so to speak, and file their returns. And so this procedure, this practice, limits the criminal prosecution exposure because the IRS is allowing an avenue in order to file returns or to deal with these issues. They want people to come forward. The flip side is they're going to limit the criminal prosecution exposure. The key point is that unreported income must be from a legal source, not an illegal source. There has to be actually pre-clearance from IRS criminal investigations. There's a form to do that. Once accepted, returns will be subject to audit. You have to, one of the conditions that you have to agree to pay all tax, interest, and penalties. And then civil fraud will be applied to the year with the highest tax liability. So while there is a financial hit, especially from a penalties aspect, the benefit is that it does limit the criminal exposure and keeps your freedom. Or not keep, guarantee, but it limits the ability, limits your criminal exposure. Just keep it at that.
Richard, a quick comment on quick question on the fraud penalty. That's the 75% penalty of the outstanding tax liability.
You want to jump in on that, David?
Yeah, I was actually going to make a couple comments on this slide, if you don't mind.
Yeah.
So the fraud penalty that we're talking about in this context, it's 75% times the underpayment. which is usually the same as the deficiency. It's the amount of tax that should have been on your return but wasn't. So not only do you owe the tax, but you owe 75% on top of that and the interest on both the tax and the penalty. And a couple of the notes on filing delinquent returns and voluntary disclosure. As far as limiting the penalties, if you're delinquent, you can file a delinquent return and it's not going to be fraudulent. That's usually a good idea. One, because it can qualify as what's called a qualified amended return, which basically means that there will not be penalties asserted against it, the tax reported on that amended return, if it's filed before the IRS starts an audit or otherwise gets information about the taxpayer for that year. So that's one good reason to file a delinquent return is to either an original return or a amended return can qualify as what's called a qualified amended return. Like Richard mentioned, mitigating fraud penalty and fraud referral. As far as the fraud penalty, the first factor that the court looks at when analyzing a fraud penalty is, did the taxpayer file returns? So not filing a return can be a factor for the fraud penalty as well. And then on the voluntary disclosure practice, I'll note that they changed the form about, was it a little less than a year ago, and when you do a voluntary disclosure practice, and they added a checkbox that basically you had to certify that your violation was essentially criminally willful when you submitted this. So, which a lot of practitioners then gave them pause because they didn't, maybe their clients, violation didn't quite rise to that level that they wanted to actually certify that, and they don't want to hand something over that says, yes, we committed a crime, because then if for some reason the voluntary disclosure falls through for whatever reason, now you've just handed a party admission to the other side that could be used against them. I will note that that form was just changed in the last month or so, month or two, to take that check mark off. So that means voluntary disclosure practice, which went into a complete disfavor over the past year or so, might now potentially be an option, although it's still a very tricky process because one of the reasons they can do a criminal referral and kick you out of the program is for lack of cooperation, which could be basically the revenue agent doesn't think you're providing all the information that you should. So it becomes kind of more of a subjective standard for whether you end up getting kicked out of the program and into a criminal case. So that's one thing to weigh with VDP. Yeah, go ahead, Richard.
Sure. Well, yeah, it's very important. Yeah. So, I mean, listen, the point of the voluntary disclosure, I think just for a second is it's a discussion to have. That's why, going through this sort of with our clients, it's not a one size fits all to everyone. And I think that's sort of the point. It's factual. It's you need people to sort of walk you through and help, clients, sort of whether it's the right fit for them, what their risk and go from there. Because there's different options. So, the next thing is sort of past IRS audits of flow-through entities. As corporations and partnerships, historically we're rarely audited. Audit rate for 2021 is shown on the chart. It's pretty low. It used to be about 0.2% audit rate, 1 in 500. Now it's less than 1 in 800. Audit rate is 3 times higher for individuals and 4 times higher for C corporations. And so, there is just a higher audit rate for individuals and C corporations. But we wanted to sort of show this chart to give people an idea of what's going on. So recently, the IRS announced that it's establishing a special pass-through organization within the IRS, Large Business and International LB&I for short division, to focus on large pass-through entities. Partnership cadres, what they're called in Southern California and across the United States. Started in Orange County, and David alluded to that, expanded to the Southwest and then to the United States. The idea is that there's going to be recruitment of additional flow-through specialists. IRS counsel attorneys may get involved, and more local and national training, because these partnership tax as a whole is generally more the complicated type of tax law. And there also is a new partnership audit regime. What was TEFRA now is BBA, and we'll talk about that in this slide. So some practical considerations for flow through, especially flow through examinations. Number one is ensure the partnership returns and operating agreements are ready for the BBA audit, which started in tax year 2018. Particularly, you want a partnership representative. And just a short little difference between TEFRA audit regime and the BBA audit regime is that the BBA pushes things more towards the partnership representative, and the individual partners have less of an input upon what's going on during the examination. And so that means that when clients are involved in a BBA partnership or the BBA partnership audit regime, it's important that you have early on when the partnership is being formed or as it's being operated, who the partnership representative is going to be, because they will have a lot of say in how things go. And then the next option is to decide whether to elect out of the BBA each year. There's an election you can make. Another thing to consider is which partners would owe additional tax, and that's sort of the operating agreement can help with that. So in short, either partnership tax, and especially partnership, the procedural aspects of a BBA partnership audit is complicated. So either our suggestion is learn the stuff, which is great from a knowledge base, or David and I have, we actually have quite a big case in the BBA partnership realm right now. So, this is stuff that we do and our firm does pretty consistently. So that's sort of the general background. I now want to turn to what.
Oh, sorry. Just one thing I wanted to
Yeah.
note on BBA is just when advised, especially if a partnership has the ability to elect out, they should seriously consider doing so. And the reason I say that is just that we've seen some kind of strange and convoluted adjustments related to BBA. And so I think part of what it is that the people inside the IRS who are handling these are trying their best to understand the rules, but maybe not necessarily applying them in a way that makes complete sense all the time. For example, the most extreme example we've had was we have a client where there's two businesses, one provides services to the other. They determined that one company picked up another amount of income. Just use a round number, say $1 million. They have $1 million of income. Other business gets $1 million deduction. $1 million deduction business is under a BBA audit. And they say the $1 million deduction creates an underpayment that requires additional tax because the amount of the 199 cap A income amount or deduction goes up. Or because they got additional deduction, some aspect of 199 cap A goes up, and that up creates tax. It doesn't make sense why you'd owe additional tax if your income is going down because of an additional deduction. But that's kind of where we're at, and trying to convince people that that's not correct is a hard process to do. So just, I think if we were outside of BBA, that's an easy call. A deduction reduces net income. Easy, we're done. Inside of BBA, it suddenly becomes this convoluted calculation with talking to experts and who kind of maybe get too far inside their own heads in terms of what the actual right result is, and not looking at the big picture. So it's just something to consider with BBA audits, and if you have the option to elect out, whether that would be a better option if you were ever audited.
Yeah, I think there's essentially a lot of kinks that need to be worked out, especially
Right.
tax. I haven't worked at the IRS and national office. A lot of things take a long time to really all the kinks to be worked out. With the BBA regime, it's new. I mean, 2018 sounds like it should be old enough, but it's really not. It takes many years for the guidance, case law to really develop a procedure. And I think, we've seen where there's just what we think is just wrong, right? And so, but those things have to then, be worked out at some level. And so we're going through that process. But that's, I think to David's point, I think it's something that the partnerships should seriously consider. Okay, so now I want to turn to just give a brief overview. We gave the background and high wealth, high income, and non-filers, voluntary disclosure, and different things like that, and the partnership cadre. Now we want to talk about specific topics that potential for abuse. They're not all necessarily abusive, but where there's a potential for that are highlighted transactions that the IRS has either noted or that we've come across in our practice. So just a quick run through: abusive micro-captive insurance transactions, syndicating conservation easements. The next is going to be anticipated sale of an asset with a low basis, where there's going to be a lot of gain. Some promoted ideas that we've seen and the IRS has highlighted number one is multi-pension plans, number two is monetized installment sales, some gifting practices, as well as QSBS qualified small business stock. Then we'll talk about deferred structured legal fees, foreign bank accounts, and what we call sort of keeping your business clean, which is business aircraft campaign and constructive dividends. So I'll now turn it over to David to talk about abusive micro-captive insurance transactions.
Yeah, thanks, Richard. So all of these topics are areas where the IRS, specifically LB&I, who handles the global high wealth area, has designated these as particular areas of interest. Some of them are listed transactions, like microcaptives in certain contexts are a listed transaction or transaction of interest. And so we want to run through a few of these because we're still seeing clients come to us saying, hey, I'm thinking of doing this type of transaction. What do you think? Or, hey, I just got audited and I entered into this transaction. Please help. And so the first one we're going to talk about is abusive microcaptive insurance transactions. So there we go. A few definitions first. Captive insurance. Captive means that the insurance is provided by a company that is often a wholly owned subsidiary of the insured company or a group of related insured companies. Microcaptive specifically means they're making an election under 831B, as in boy, because the premiums that are received by the captive insurance company are under the $2.2 million threshold. Well, it's indexed, so I think it's a larger amount now. So larger companies have used captive insurance for a while. BP used it to help pay for the oil spill in the Gulf of Mexico. The main tax court case, the first tax court case on captive insurance was a case called Rent-A-Center. And that actually involved, the place where you can go and rent things for a short period of time. And they had locations all over the country. They had, needed, workers' comp, slip and fall insurance, liability insurance, all that kind of insurance for all these different locations, all these different places. They said, hey, we're paying all this insurance premiums. Let's just bring it all together in one place, insure it all internally, and we'll actually save money as a business. That makes sense. It needs to make sense from a business perspective. But then, some people saw these provisions and thought, oh, this could be used for other techniques. So like I mentioned, 831B, total premiums must be less than 2.2 million. The nice part about the election from a tax perspective is that the insured party can deduct the premiums paid, but the insurance company doesn't pay tax on the premiums received. They only pay tax on the insurance or the investment income that they receive by investing that money and holding on to it. So because of that mismatch of deduction now, no income pickup immediately, there's the potential for abuse there. And some of the abuse could involve the captive insurance company making loans right around back to the owner of the insured party, or potentially maybe the kids own the captive, so it has like an estate planning component to it. These are some of the more abusive cases that we've seen. Originally, it was identified as a listed transaction back in 2016. If you've been following all the fun issues with the IRS and the Administrative Procedure Act, basically this notice got invalidated saying, hey, you have to issue a regulation subject to notice and comment period in order to identify a listed transaction. So in January 25, they finalized those regulations, identifying transactions as listed transactions and other ones as transactions of interest. There needs to be an additional component. It's not just any arrangement with an 831B microcaptive. There needs to also be a loan back or a bad, a debt to equity kind of ratio. But yeah, there's potential for a 40% penalty under 6662I, potential 75% civil fraud penalty in this context, and the potential to get hit with income multiple times, which is what happened. For example, the Abrahami case is the first one under the since then category. So as I mentioned, Rent-A-Center, initial taxpayer victory in the context for a large captive. Since then, on the microcaptive side, there's now been 11 IRS victories. Part of this might be a selection issue that if the IRS knows they're going to lose, they don't take it to trial. So the cases that do go to trial are the ones where the taxpayer somehow feels that they might win, but the IRS is convinced that they're going to win. And so far, the IRS has won every one. And so it's not a good setup for for taxpayers wanting to enter into, especially 831B micro captive transactions. Now is probably not the time to do that. I know some people are pitching, hey, don't make the 831B election. Instead, just be a large captive insurance company. There are still risks associated with that, especially if there's going to be loans or other type of ways that the owners of the business will benefit from the funds that are in the captive. So you just have to watch out for those because the IRS is looking for these transactions, and they have certain settlement programs that you can enter into to try and resolve it in a uniform way. But there's a lot of interest in the IRS for these transactions. I mean, I had a client come to me 2 weeks ago and say, like, I'm thinking of doing a captive transaction. And I said, well, you really got to make sure it's worth it and that it makes business sense. That it's not just I get a tax deduction that benefits me. It needs to be even without the benefit of the tax deduction, or even assuming the money in the captive is no longer yours or your business's, this needs to make sense from a financial perspective. And so that's really the way to look at it. And a lot of the old transactions definitely didn't meet that kind of smell test. But yeah, the IRS is definitely interested in these micro captives. There we go. There we go.
Yeah. So the next thing we're going to be talking about is syndicated conservation easements, something I actually worked on when I was inside the IRS. So what is a conservation easement? Well, a conservation easement is an agreement when the owner agrees to permanently restrict the use of land to preserve and protect for conservation purposes. It's generally the transaction is going to be between the owner and land trust or government agency. The land trust receives an easement and oversight of the land, and it's generally, right, as we said, for conservation purposes, the environment, or the other list of purposes. There's a special tax code provision, 170H, which allows a charitable contribution for these types of conservation easements. There's a lot of requirements, and the regulations are quite extensive to make sure that you're meeting the requirements. One main requirement that generally is sort of the easy one to think about is the easement must be in perpetuity. It can't just be for 5 years, for 10 years, 30 years. It has to be in perpetuity. It can't revert back to the owner. So what makes it syndicated? Well, syndication is a group of investors that pool funds to acquire land and then donate the easement to the land trust. And so, it's a partnership in most cases where they are getting investors, individual partners to invest. Okay, so how do you value the charitable contribution? This is where things can be an issue. The value of the charitable contribution is the value of the land before the donation of the conservation easement minus the value of land after the donation of the conservation easement. How do you determine the value of the land before the conservation easement? Well, you get to use actually what's called the highest and best use of the land. And that's where there is some potential for abuse. So, for example, land in rural and remote areas. It's hard to argue that the highest and best use is going to be some residential development. For example, swampland that can never be built on. Say there's going to be a large, apartment building or something like that. Is you can't really. It's hard to argue that, and that's where the abuse comes. And what we've seen and what the IRS has gone after is schemes that involve promotion materials that claiming the charitable contribution is going to be well in excess of 2.5 times the investor's investment in the scheme, right? 5 times, 10 times. David and I had a client, that was involved and was, had no idea this was a problem, and now they're, the conservation easement is, basically being denied, the deduction, I should say. So how has the IRS treated this? Well, regulation, 1.6011-9 identifies these as listed transactions, has to be disclosed on a form 86, which highly increases the likelihood of an audit. In 2019, the IRS added them to the Dirty Dozen list for tax schemes, and there are potential penalties, 40% under 66, 62E or I, and then there's a 75% for fraud, potentially. IRS is pursuing promoter investigations of any marketing or promoters and trying to sort of go to the source of these things. Promoter penalties, which includes penalties, injunctions, or criminal charges against those that are promoting these types of transactions. And to be clear, there are conservation easements and even syndicated conservation easements that are fine. It's just when there's a high potential for abuse, and that's what's causing the IRS to take another look at these, or not a closer look at these. So IRS notice and chief counsel notice. The IRS essentially is settlement proposals. It's actually interesting, since the IRS has taken a look at these more closely, you would think that there'd be less of these conservation easements, syndicated conservation easements going on. When my time at the IRS, it only increased, actually. The number of syndicated conservation easements were only going up, even though the IRS was taking a much closer look at these. So as a result, the IRS has a settlement proposal, and the terms are going to change. But every year they not every year, every once in a while they do change the general terms of the settlement. But and these are going to be offered to some but not all cases in U.S. tax court. Dave and I just had a client recently that was, a partner in one of the partnerships that, again, the partnership representative, getting back to the BBA, the partnership representative was the one calling the shots. The partners in the partnership didn't have much of a say, but they were given this settlement offer. And so the terms are generally going to be the charitable contribution is disallowed in full. Taxpayer can deduct the cost of investing in the entity. So whatever money they put in to the partnership, they can, get to deduct the cost, which it also includes, any additional cost of the contribution, accuracy related penalties between 10 and 20%, and potentially an additional smaller penalty for failure to disclose it as a listed transaction. And so the IRS has really, identified these as being a point of, closer looks. To look at these things much closer. So now I'll turn it over to David for the next topic.
Yeah, so the next big picture topic we're talking about is, business owner is going to sell an asset with a low basis, high value. We have a lot of these right now because of the baby boomers kind of retiring out and selling their businesses off to kind of the next generation of business owners. And so there's a lot of these kind of different options floating around. One of which that was floated around is involving Maltese pension plans. It was added to the Dirty Dozen list for 2021 to 2024. It's questionable whether it's actually in the 2025 list, but it's the general idea of it is you contribute an appreciated asset with low basis to a pension plan. Usually not necessarily an operating business, but it's a trust formed in Malta. There's many rules related to the proper running of this pension plan. You sell the appreciated asset inside the pension plan, use the proceeds from the sale to make a lump sum distribution out, and then use the remainder to set up an annuity for the life of the U.S. person. That's the idea of how it's stated. The potential tax results is that under Maltese law, the sale of the asset in the pension plan is non-taxable. Under the U.S.-Malta Treaty, sale of asset also non-taxable in the United States. Lump sum distribution, same, not taxable in Malta or the United States. And annuity payments are partly taxable under Section 72 annuity principles, where part of it's return of contract, part of it is a taxable portion. That's kind of the basics of how it's laid out. So IRS obviously doesn't like this idea. And so the first thing they did is they went to Malta and said, basically, sign this. And it was a competent authority agreement that says, it was signed in 2021. Basically, focuses on the definition of a pension fund under the U.S.-Malta Treaty. So it doesn't really attack the transaction on its face. It more looks at the definitional aspect and says that these types of arrangements are not a true pension fund under the U.S.-Malta Treaty. It's questionable whether the CAA is on sound legal footing, procedurally or substantively, and it hasn't been challenged yet. That's one of the big things with Malta versus some of these other ones. With Maltese pension plans, it's more at the early stages right now. There's no tax court cases on it. There are some audits going on, some other things going on with Maltese pension plans, but nothing's been determined by a court yet. It was identified as a proposed listed transaction. Those regulations were issued in January 2023. They have not been finalized yet. It's unclear whether they're going to be final regs on it. But that's, and like I said, there's no tax law on it yet, but it's something to be aware of, that this is an area of interest, definitely an area of interest for the IRS in terms of how to combat and make sure people pay the full amount of tax on the sale of their business or sale of an appreciated asset.
David, I have David, if it's, I
Yeah,
have a quick question on the Maltese pension plan. If you can go back one slide.
yeah.
The initial contribution by the U.S. taxpayer of the asset, I assuming it's going to be an appreciated business, into the
Mhm.
pension plan. Are the taxpayers taking the position that that itself, the transfer of the business into the pension plan, is a non-taxable transaction? There's no realization event?
Correct. The position has been taken that it is treated as a grantor trust. The pension is, and so therefore, there's obviously filings that go along with that, like a 3520A, 3520s, that go with it for compliance purposes. But the position is that because it's a grantor trust, it's a non-event. It's not a realization event. Yeah, good question. Next one under selling an asset with low basis is a monetized installment sale. There's one particular promoter who's been pitching this for a while out of Idaho, and he's been in a protracted fight now with the IRS on many fronts. But yeah, there's a whole team inside the IRS dedicated to taking these ones on, and it's on the Dirty Dozen list and has been for several years. The general idea is same thing. Taxpayer wants to sell an asset, generate substantial gains. Taxpayer really wants the cash, but doesn't want to recognize all the gain in the year of sale. Um, and doesn't want to risk that the buyer can't make the installment payment. So it doesn't want to do a straight installment sale with the buyer of the asset. So taxpayer engages an intermediary, assigns to the intermediary, the right to receive payment from the buyer in exchange for installment payments from the intermediary. Lending company then makes a loan for almost 100% of the sale proceeds back to the taxpayer that are essentially collateralized by the right to receive the payments in the future. So you get almost all the cash back immediately, and then the loan payments on that loan are funded by the annual or monthly payments from the intermediary. So it ends up being like a circle of funds. The purported tax results is that the taxpayer defers the gain from year of sale. Instead, gain is reported ratably as payments are made by intermediary to the taxpayer, and then taxpayer maybe receives an interest deduction for interest on the loan payments, depending on if it's personal versus business interest. That's the idea, or how it's pitched. In 2015, IRS started a promoter investigation involving the person I talked about, Stanley Crowe. IRS is seeking to impose penalties under the main promoter penalties. A lot of litigation involving Mr. Crowe. So if you Google Stanley Crowe monetized installment sale, you'll see a lot out there. There's a chief counsel advice that we provided a link to that shows 6 different ways that you can attack a monetized installment sale and why it won't reach the desired result. It's basically a roadmap so that if you ever have a client who has one of these and the IRS is coming after them, you can kind of go through these and see if there's different ways to combat them. Most of the time, honestly, there's not, if you're following this kind of thing. I've had a couple cases where I've gone through settlement programs inside the IRS to resolve these. There's usually not very good facts if you're going through the way the program was originally set up. It was identified as a listed transaction. Like the Maltese pension plan, it has not been finalized yet. And there's, some people said, oh, the definition of listed transaction is too broad. It might sweep in some legitimate non-abusive types of transactions, but we'll see what the IRS does with the final regs, which if they issue final regs on this one.
So next we want to talk about, just under the topic of selling an asset or a company with, large gain coming down the pike. So gifting practices. So gifting, talk about the idea of assignment of income. So what is the assignment of income? It's a case-based doctrine, which essentially is gifting appreciated property after the transfer is practically certain to occur. So for example, company A is about to sell to company B. Right before the transfer, company A tries to, eliminate some of the the tax they're going to get from the sale. They try to transfer part of ownership of the company to a charity. Case, base law, Lucas v. Earl, Supreme Court case back from 1930, talks about this topic, which says that it disallows the transfer for all intents for tax purposes. The government is the IRS is going to look at whether the transaction was practically certain to occur. Arrangement, to quote the court, arrangement by which the fruits are attributed to a different tree from that on which they grew. And so what are the typical facts I alluded to? A transfer of appreciated property is anticipated, right? So it's going to happen. You're going to sell. It's about to happen. In order to reduce the amount of tax related to the transfer, a taxpayer will gift a portion of the appreciated property, generally to a charity. And if it's, that if the transaction, if the sale was practically certain to occur, then the IRS will claw that back. Essentially, you pay the tax on that portion that you donated, then you get the charitable contribution deduction afterwards. So you do pay the tax. And so the determining factor is whether something was practically certain to occur at the time of the donation. Highly factual cases. I worked in this at the IRS quite a bit. David and I have had a couple cases together outside in this area. It's going to be drawn out in terms of just really have to develop the facts and really need to know dates when something was practically certain to occur. And that's generally, not just a one size fits all. It's going to look at sort of what things were happening on a day-to-day basis, really from the date that the donation was made of the appreciated property until the transfer of the asset or the company.
Yeah, and I'd add on that one that usually the IRS is going to attack both the anticipatory assignment of income and potentially attack the gifting too. Say there wasn't a qualified appraisal, it wasn't a qualified appraiser, those kind of standard charitable contribution issues. And like Richard said, it's very factually based. And when representing a taxpayer in this area, the focus is on, hey, there were still all these deal breakers. This deal wasn't practically certain because of A, B, C, D, E, and F. That could have derailed the deal, and those deal breakers weren't resolved until X date, which was after the charitable donation. It's very factual and requires a lot of work. So it is possible to do this where you can get the charitable deduction and not have to pick up the capital gains on those shares. But it requires a lot of being very specific and intentional about making sure that you're keeping track of where the deal is at and what the status is, and having documents necessary to show that this deal wasn't certain on the date of the gifting.
Yeah, it's really creating a timeline, right? This date, really laying out the facts, and it's a voluminous sort of procedure, but to make sure that it's as clear as possible. And these cases happen, right? Where I see financial advisors, financial planners sort of advise clients, hey, you're going to have a huge tax bill on the sale of your company. Why don't you gift some of it to, charity? And these are sort of things to where this happens, right? And this is the doctrine that can, while there is good intention to not pay tax, the capital gains tax on the sale on that portion that's donated, turns out that you may have to. And so it's important to understand the doctrine and really note what's going on during that time period. So that leads us directly into this topic of non-cash charitable contributions in general, as David mentioned. There's a lot of rules in regards to that, and we'll sort of highlight some of the what I see high level most important ones. For non-cash donations over $5,000, the donor must attach Form 8283 to the tax return to support the charitable contribution. And so the focus from the IRS's examination purposes, they really focus on this form. Why? Because failure to comply can result in a disallowance. For example, not even attaching the return, missing some information, missing all the information. And that's just a couple of examples. So again, very case based in terms of what's going to, meet the mark. But there is a fail safe, but something that substantial compliance is that if taxpayers substantially comply with Form 8283 and all the requirements for non-cash charitable contribution, that the donation will still be, the contribution deduction will still be allowed. Bond v. Commissioner is the case that set that doctrine up. But getting back to sort of anytime there's this and it's not done, to the T perfectly, the question always is for clients is, did you substantially comply? Let's lay out all the things, all the requirements, and see whether or not, and is there a case that's on point to that? One of the things that does come up is there does require an appraisal. That means a qualified appraisal and a qualified appraiser. And that's something, that needs to be, with the return as well. In addition, something that comes up is valuation. How much was it valued really? You had a qualified appraisal, but maybe the appraisal was much higher than the IRS thinks it. They have their own appraisal, and sort of you get into arguments over valuation, something that that we deal with, and you need maybe a third party. There's a lot of stuff that goes into the valuation part, and that's sort of with IRS what may attack large dollar contribution, not dollar, but large non-cash charitable contributions. The next thing I want to talk about is something that we've seen sort of more recently start to pick up a little bit more. It's what's called the qualified small business stock. As David mentioned, as a lot of people work on selling their businesses. Maybe they've doing this for a long, the boomer generation retires, and even people that grew a company and want to sell it, trying to eliminate the gain on the sale of their company. So what is the qualified small business stock? It's an exclusion. It refers to stock issued by a domestic C corporation that meets specific eligibility criteria under Section 1202. If the requirements are met, a taxpayer may exclude a portion or all of the gain from income when the stock is sold. So there's some key requirements, and we'll talk about that on this slide and the next slide, and we'll talk about how the OBBBA, one big beautiful bill act, changed that. But the key requirements for all intents and purposes are the issuing entity must be a C corporation with total gross assets not exceeding $50 million. It must be the original issuance. The taxpayer must acquire the stock at its original issuance. Qualified trader business must operate in a qualified industry. A 5-year holding period. The stock must be held for at least 5 years, and we'll talk about that. How the OBBBA changed that. And then the post 1993 issuance. The stock must be issued after August 10th of 1993. So the law prior to the One Big Beautiful Bill Act is 100% exclusion for stock acquired after September 27th of 2010. 75% exclusion for stock acquired between February 18, 2009 and September 27, 2010, and 50% exclusion for stock acquired before February 18, 2009. Maximum exclusion under the old law was greater of $10 million or 10 times the adjusted basis of the stock. The issuing entity must be a C corporation with total gross assets not exceeding $50 million. So the One Big Beautiful Bill Act made some changes. Instead of those dates, 2010, 2009, etc., it creates the following: 50% exclusion if held for 3 years, 75% exclusion if held for 4 years, and 100% exclusion if held for 5 or more years. Increases the gain cap from $10 million to $15 million, and also increases the eligibility of exclusion by increasing the limit on the corporation's aggregate gross assets at the time of issuance from $50 million to $75 million limit. And so it's becoming more popular. We've seen it more, a lot of promoting sort of different ways of maybe meeting the requirements of 1202, that the IRS is starting to look out further, and we believe the IRS will continue to look at things further, especially during audits, high income returns, which is what we're talking about today. Issues generally flagged are, failure to meet the qualified trader business standard, improper documentation, stock held in pass-through entities without tracking, and misunderstanding of the conversion rules. And so, meeting this 1202 requirements may not be, not every company is going to meet it. And so there's been some aggressive approaches in terms of forcing people or companies into that to try to meet those requirements.
Yeah, so we only have about 5 minutes left, and we still have about 10 slides to go. So I'm gonna buzz right by deferred structured legal fees and just note in general that this is another area of interest for the IRS. There is a case from the 90s that allows it to be done. Basically, the idea of it is that a plaintiff's lawyer is going to get a contingent legal fee. They enter an agreement with a third party. They get annuity or installment payments over time in exchange for assigning the right to that contingent legal fee. And this actually worked in Childs v. Commissioner, but the IRS is looking to now attack this more. So just be on the lookout for that. There's a GLAM, General Legal Advice Memo from 2022 that talks about it. Attacks kind of a fact pattern that's much more aggressive than the taxpayer in Childs. So just be aware that that is out there. Another one that's kind of an oldie but goodie in a sense, because the IRS has been interested in offshore enforcement since the mid-aughts. And even before then. And so this is definitely an area. I mean, when I was inside the IRS, this is one of my areas of expertise that I worked on a lot starting in 2009 when I joined the IRS. And so, obviously there's offshore assets, non-compliance. You could be looking at FBAR penalties, foreign information return penalties. And this is definitely an area that the High Wealth Group looks at. They have a lot of expertise in offshore matters. There's all these different ways. I won't go through the slide because we're running short on time. But basically, the IRS, especially LB&I, has specific targeted programs for all these different areas and aspects. And a lot of this comes down to more information gathering. Especially with FATCA, there's a lot more information that the IRS is gathering about the foreign activities of U.S. persons, including where they hold the accounts, the balances, and all of that. But just note that if you have a client who's not compliant with offshore matters, there's still time. There's still programs that you can get into, including the streamline programs that can allow them to come in from the cold and pay a bit of a penalty and kind of move on. So that's what I'll quickly say about offshore matters.
Sure. So picking right up. So business aircraft campaign, that's a campaign that IRS Large Business International Division updated its list and add the campaign. The idea, and just to quickly go through this due to time constraints, but business, personal use of business jet. It's a way for the IRS to maybe have a springboard into, that web of what I call the web of related entities and related parties when it comes to high wealth or high income and taxpayers. Typical compliance issues are going to be imputed income for personal use, value. How do you value that use? Is there depreciation being taken when there's personal use? Whether deductions are expenses are deductible, and then excise tax issues. And finally, what we call, keeping your business clean, constructive dividends. And that's, when shareholder of a generally closely held corporation receives a payment from the corporation that they own, and they try to call it a loan when there's, the idea is that there's not really a loan agreement or a intent to repay. And the IRS will try to look at these whenever there's loans to shareholders. They want to, that's generally going to be a point of just wanting to look at that a little further. Is it a disguised dividend, right? Is it really just a dividend that you're making to your shareholder? And it's not even, it's not really a loan because you haven't actually tried to pay it back. There's no interest. There's no, and so that can create, a payment that can create a income for the shareholder. And so that's something that, that we do see. And that generally comes up, payment of a shareholder personal expenses, payments well in excess of the value of the services that the shareholder is providing for the corporation, and the idea of just a loan versus a dividend. So with that being said, David and I are happy to, I guess, answer any questions if there are any on this, presentation. But even after this presentation, we're happy to be a resource. And here's our contact information. And if you have any questions or you have any clients that have some of these issues or stuff related to what we do, we're happy to be to answer those questions.
I'll just give it another moment here if there's any questions.
I'll just make one more note. I'll just make one more note while we're waiting for questions. It's just that there might be some questions about like, well, what about with the IRS decrease in number of people working? What's going on with that? And I will say for global high wealth, especially, there were a lot of new people who were hired who at the IRS who had a lot of outside expertise. They were brought into these global high wealth audits who were some of those provisional or probational employees who were then let go. But it's interesting. I'm hearing now that the IRS is looking to hire again to bring back some of those people or not let some of the people who took deferred resignation go because they're realizing, oh, wait, we need those people to run these programs or to help with the filing season or to whatever the case might be. So it's unsaid as far as what it's unknown at this point, what exactly the IRS is going to look like 6, 12, 2 months from now, 2 years from now. But this is definitely an area of interest for the IRS with these kind of global high wealth audits.
Yeah, the IRS is the biggest tax collector in the United States, and they need resources and they need people to do their job. Otherwise, what's the point, right?
Right.
Yeah. Thank you very, very much, David and Richard, for this presentation. You provide us a lot of information and a great resource with the PowerPoint slides. The telephone contact information, their emails are here. If you would like to reach out outside of this presentation to them directly for new business opportunities or for any questions, you're welcome to do that. And thank you everyone for attending. Have a nice